This is an ABC News special report. Now reporting, David Muir.
Good morning. We're coming on the air because the Supreme Court has just handed down an historic ruling concerning Colorado's attempt to bar Donald Trump from the presidential ballot in that state. The decision coming just one day before Super Tuesday, when voters head to the polls in 15 states, of course, including Colorado. Just moments ago, in the case of Trump versus Anderson, the justices ruling in Donald Trump's favor, saying Colorado has no right to keep his name off the ballot this November. The state had argued he should be disqualified under the 14th Amendment's insurrection ban because of his actions leading up to the January 6th attack on the U.S. Capitol. But the Supreme Court just moments ago saying Donald Trump will remain on the ballot. Let's go to Terry Moran live at the Supreme Court. Terry, what have you been able to read so far?
Well, David, a rare moment of unanimity on a usually divided court. All 9 justices of the Supreme Court agree that states cannot kick candidates off the ballot under the 14th Amendment, that clause which you mentioned, which passed after the Civil War, held that people who had sworn an oath to uphold the Constitution and then engaged in insurrection are banned from holding federal office further. And what the Supreme Court said is that states can't enforce that it requires Congress to pass a law to outline how that clause should be enforced, concluding very simply that responsibility for enforcing that part of the Constitution rests with Congress and not with the states. The Supreme Court expressing real concern that states could go different ways. Some states would perhaps ban one candidate, some states perhaps ban another candidate. Other states keep them both on the ballot, and they express concern about the disruption that would work. They also said that the text of that constitutional article is clear and that it requires Congress to pass, quote, appropriate legislation in order to outline the enforcement procedure for someone who had done, as people have alleged, sworn an oath to the Constitution, then engaged in insurrection and run for office again. Nothing will happen. Trump will stay on the ballot in all 50 states.
And we should point out, Terry, that he is on the ballot. His name is printed for Super Tuesday tomorrow in Colorado, so voting will continue as planned.
That's right, because the Colorado Supreme Court, which originally held the opposite, that under the Constitution, Donald Trump would be banned from running for office, from appearing on the Colorado ballot. They said the Secretary of State should go ahead and prepare for both possibilities, pending Supreme Court opinion. Here we are the day before the Colorado primary. Supreme Court, once again, speaking with a unanimous voice here. Can't express how rare that is in a contested case. All the liberals joining with the conservatives in holding that Congress has the authority to keep people off the ballot under the 14th Amendment, not the states one by one.
Up to Congress, as you point out. Terry Moran leading off our special report here. Terry, thank you. Wondering, Kate Shaw, our legal analyst. And Kate, as we heard Terry point out, they're unanimous in this decision, the justices on the court, and sending a very strong message that when it comes to a significant national issue of this sort, it should be Congress and not the states that decide here.
Well, David, the justices did all agree with that proposition. And interestingly, this opinion is a per curiam opinion, meaning there's no specific identified author. It's sort of a depersonalized opinion of the court. But I should mention there are a couple of concurring opinions. Justice Barrett writes separately to concur, and there's a joint separate concurrence by Justices Sotomayor and Kagan and Jackson, the 3 Democratic appointees, all suggesting that the court actually went further than needed in this case, essentially saying the only way to enforce this provision of the 14th Amendment is by Congress. But just as Terry said, the bottom line is unanimous that Colorado has to keep President Trump on the ballot, and so does every other state. So I think we're done with seeing state litigation around this question.
It was interesting, Kate, because we had a bit of a preview that this was coming, including the liberals on the court when they heard arguments in this. Elena Kagan had said, I think the question that you have to confront is why a single state should decide who gets to be president of the United States. This was at one point to a lawyer arguing against Trump's position. She went on to say, in other words, this question of whether a former president is disqualified for insurrection to be president again, just say it, she said. It sounds awfully national to me. Strong suspicion that she would go this way along with the other liberal justices.
That's right, David. It was interesting that at oral argument, you did not see the ordinary ideological divides on display. Everyone on the court seemed quite concerned about what it would mean for a nationwide election in which we are choosing a national leader for everyone, for individual states to have so much control over something as important as whether a presidential candidate appears on the ballot. That's an argument about consequences. That's not really grappling with the history of this provision of the amendment or the intention of those who added it to the Constitution. That's really about consequences. But you saw that front of mind in the oral argument, and I think you see it on display in this opinion.
And bottom line, Kate, what does this mean for other states who have found similar findings as Colorado? As you know, a number of states have gone in this direction.
That's right. You had Colorado, Maine, Illinois. I think this opinion puts those to rest. At this point, none of those separate state decisions, whether by courts or by Secretary of State, as in Maine, to keep Trump off the ballot can go into effect. So he will either be or remain on the ballot in every state. I don't think there's any way for a state to try to circumvent this ruling. At this point, any action has to be in the hands of Congress, and that's what the court said pretty clearly.
So it would appear this issue is off the table for good straight through the presidential election. Kate Shaw, our thanks to you as well. I want to bring in Devin Dwyer, who also reports on the court for ABC News. And Devin, you're reading through the decision, a bit of a warning also, though, from some of the liberal justices.
That's right. And Kate just touched on that here, that the liberals were saying the court didn't need to go as far as it did. But take a step back for a second, David, on just how historic this decision is. Never before has the Supreme Court considered this part of the Constitution, so historic in that way. But not in more than 20 years has the Supreme Court directly weighed in on a presidential election months before voters are going to the polls. Obviously, going to the polls now in the primary, but the general election in November, this is a really big deal. And it's just the appetizer. The Supreme Court, in this opinion, which is unsigned, it's unanimous, they don't talk about Donald Trump's conduct. There's no specifics about what is alleged he is alleged to have done around the 2020 election. All of those questions are still to come next month, as you know, when the Supreme Court takes up another major case on his conduct.
Well, you bring that up, Devin, the fact that this was a bit of a setback for Jack Smith, the special counsel, in the federal elections case, the interference that involves January 6th. We learned that they will take up this issue of presidential immunity, obviously much different from what we're covering right here. But as you bring up, they will hear arguments. The earliest they could make a decision is May or June. And everyone at home in that case simply wants to know, is there a chance this goes to trial before the election? That window is very small.
A very small window for the Supreme Court to hear this case, this other case, give a decision, have a trial go forward before the presidential election in November. But, David, again, the underlying conduct in this decision today that Donald Trump cannot be removed from the ballot for engaging in insurrection is about to go back before the court. In this other case, the special counsel looking to prosecute Donald Trump for that very same conduct. And so these justices, again, are going to be asked to decide whether that trial can go forward, whether a president is immune. And it's really going to push this trial right up against the election when voters are going to be headed to the polls.
And, of course, the point you're making here is that while they don't address the behavior in today's decision, they're going to have to. Certainly in the weeks ahead, we'll continue to follow that. Rachel Scott covers the campaign trail for us. Rachel, reaction already in from the former president?
Yeah, the former president just responded just minutes ago. He's calling this a big win for America. I'm also told that former President Donald Trump is expected to address this decision in just a matter of hours down in Florida at Mar-a-Lago. The Trump campaign was not only hoping that this decision would come down in this way, they were confident that it would happen. They called the Colorado State Supreme Court ruling flawed. They said they had the utmost confidence that the justices would ultimately rule in their favor. And of course, this all comes now just one day before Super Tuesday. We know that 800,000 voters in Colorado have already mailed in their ballots, Donald Trump's name on that ballot ahead of tomorrow, and the justices making sure that those votes are counted, and it stays that way, David.
All right, Rachel Scott with reaction from the former president, John Carl, our chief Washington correspondent right here in New York with me. And John, ironically, this amendment was made to reduce the power, not increase the power of the states here. And certainly what they've avoided here is a patchwork of states where Donald Trump is on the ballot or not on the ballot. That's just simply not going to happen.
It's fascinating to read this opinion. They make both of those points. One, they talk about how the 14th Amendment, of course, coming after the Civil War, was designed to keep the Confederates from coming back into power, envisioning a situation where Confederates would take over the state legislatures of the former Confederate states and use that power to try to sway, to try to sway the federal government. So this talks about how, no, this amendment was not designed to expand state power. It was designed to limit state power. So the idea that we would give the states, through the 14th Amendment, the power to choose who or who could not be on the ballot is simply doesn't make any sense. And they talked about the practical impact as well, saying you could see different states having different reasons for disqualifying candidates from the ballot and having a different threshold of proof. Some states may say if a candidate's been convicted of the crime of insurrection, they would be banned. Others saying just simply if the Secretary of State or election officials believed that to be the case. So they said you can't have that kind of a patchwork, and they use that word patchwork, different states having different reasons for banning somebody from the ballot. It would throw our entire system of electing a president up in the air.
John Carler, thanks to you as well. I want to go back to Terry Moran at the Supreme Court because, Terry, as we were talking about with Devin there, the Supreme Court is going to have to take up this issue of immunity in the separate federal interference case that involves January 6th. But without going too much further into that case, they did give a very strong indication in today's decision that they believe ultimately who should be president really should be decided at the ballot box.
Yeah, that's a great point, David. The whole panoply of cases brought against Donald Trump in all kinds of courts, not just the Supreme Court, but courts across the country, all have basically one aim: to stop him from getting back into the White House. And what the court says in this case is that the Constitution is clear that this route is not available. And across the country, there's a sense among voters that there's something not kosher about that, if you will, that they are pushing back against this and saying that the only way to decide who gets into the White House shouldn't rest in the courts or with prosecutors or juries. It should rest with voters in the ballot box.
Terry Moran live at the court for us this morning. Terry, thank you. And again, the breaking news coverage here live on ABC. As you know, Colorado's highest court had decided that Donald Trump should be kept off the ballot in that state, given what that court believed was his behavior leading up to January 6th. The Supreme Court, speaking loudly on this just moments ago, disagreeing with Colorado's highest court, saying that that state should not be able to keep Donald Trump off the ballot. Super Tuesday tomorrow, voters in Colorado will go to the polls. They will be able to vote for Donald Trump. His name is already on the ballot, by the way, but now they have cleared the way, the Supreme Court has, for Donald Trump to be on the ballot, not only in Colorado, but in every state in this country as we inch closer to the presidential election. Our coverage continues on ABC News Live, abcnews.com. Of course, I'll be back much later today with this entire team for World News Tonight. I'm David Muir in New York. Have a great day.
This has been a special report from ABC News.